Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In our video, Open Justice, Lights, Camera, Action, we mentioned that we participated in Lucy Letby's hearing in which she renewed her application for permission to appeal. However, as mentioned then, we were at the time unable to provide further details given the court embargo pending the retrial in the matter of baby K. As you know, that trial is now concluded and we are now able to provide you with our view of the Court of Appeal's judgment. We will first give a brief timeline of the proceedings that led to Lucy Letby's application to seek permission to appeal. Then we will outline the arguments used by her to support this application and the Court of Appeal's reasons for refusing it. And finally, we will attempt to give our view on the judgment and on Lucy Letby's prospect for a fresh look at the overall case. By discussing this matter, we are aware that bereaved families and others directly or indirectly affected by these tragic events may find our intervention disrespectful and distressing. However, we want to assure them that this is not our intention. Our goal is to scrutinize the criminal justice system to ensure that those responsible for crimes are held accountable and, where possible, rehabilitated. We also take claims of innocence very seriously, as serving a whole life order for crimes one did not commit is equally distressing and cannot be underestimated. The recent case of Mr. Markinson clearly illustrates this. We are driven solely by a sense of justice and believe that these discussions ultimately serve the interests and benefit of all parties involved. Starting with the timeline, Lucy Letby was first arrested in July 2018 and eventually charged with several charges of murder and attempted murder in November 2020. Her trial, which took place in Manchester Crown Court before Judge Goss and a jury, started on the 4th of October 2022. The prosecution maintained that between 2015 and 2016, Lucy Letby, a neonatal nurse at the Countess of Chester Hospital, murdered and attempted to murder several babies by various methods, including by injecting air causing air embolism, by milk overfeeding, by inflicting trauma, and by administering insulin. The allegations were based on statistical, medical, and circumstantial evidence. The statistical evidence, the prosecution says, supports the unusual surge of death during the period in question, and the shift pattern establishes that Lucy Letby's presence was the only common denominator associated with these deaths. The medical evidence was brought in to support the fact that the deaths could have not been but the result of foul play. Incidentally, note that we are deliberately calling this medical evidence as opposed to expert evidence. This is a deliberate decision and we will get back to it later on in this video, so do follow us until the end to find out the reason for this careful choice of words. And the circumstantial evidence looked at Lucy Letby's character. Particularly, the prosecution says, her fascination with bereaved families, followed up by multiple searches on Facebook, a series of handover sheets which were found under her bed, as well as a note by Lucy Letby, which amongst other things reads, "I'm evil, I did this," which was construed by the prosecution as to amount tantamount to a confession. The defense case, on the other hand, was mainly based on Lucy Letby's statements that she denied intentionally causing any harm to any of the babies and that she was a conscientious nurse committed to her work. This explained, she said, her presence more prevalent than other nurses. As Lucy Letby began giving evidence in her defense, she sobbed and told the court on how devastated she was and how sickening it was being accused of murder or attempted murdering of this baby. When she was asked whether she had done anything wrong, she confirmed, "No, I only ever did my best to care for them. My job was my life, and I have always prided myself in being competent." She said that the whole world stopped when she was accused of these terrible crimes. Also, evidence was provided by a plumber who testified as to certain plumbing problems that had occurred at various points in the unit, which suggested issues of hygiene within the unit. The defense asserted that the circumstantial evidence presented by the Crown was largely taken out of context. For example, in relation to her searches of the bereaved families on Facebook, this should be seen in the context of hundreds of other searches she made on cases not related to the ones in indictment. Similarly, in relation to the handover sheet found in her bedroom, only a minimal part was related to the charges on indictment. The majority were unrelated. These, she said, were taken home by her accidentally and forgotten. The defense also sought to deal with the medical evidence provided by the prosecution, which they deemed substandard, making a series of applications to exclude it. These, however, were all rejected by the trial judge. The trial concluded in August 2023. There were 22 charges in total, 7 charges of murder and 15 of attempted murder. Of the 15 attempted murder charges, on 6 the jury could not reach a verdict, and on 2 the jury found the defendant not guilty. She was found guilty on the remaining 7 attempted charges. Of those, only 2 were reached by unanimous verdict. The remaining 5 were reached by a majority of 10-1. As of the 7 murders ascribed to her, she was found guilty of them all, but verdicts were all reached by majority. On the 21st of August 2023, she was sentenced to 14 whole life orders. In September 2023, it was announced that Lucy Letby filed an application to seek permission to appeal against her convictions. This was refused on all grounds in January 2024 by a single judge. She had the right to renew her application orally in front of 3 Court of Appeal judges. On the 11th of April 2024, it was announced that the matter was listed for hearing on the 22nd, 23rd and 25th of April 2024, and that the hearing will be transmitted via video link to allow remote observation. The hearing did indeed take place on those dates and was presided by President of the King's Bench Division, Dame Victoria Sharp, Lord Justice Holroyd and Miss Justice Lambert. On the 24th of May 2024, it was announced that her application had been refused on all grounds and that associated applications were also refused. Publication of a full judgment, however, was postponed to a later date. On the 10th of June 2024, a retrial into one of the attempted murder for which the jury could not previously reach a verdict took place at Manchester Crown Court. The retrial concluded on the 2nd of July 2024 with a unanimous guilty verdict. On the same day, the Court of Appeal handed down its judgment. On the 5th of July 2024, Lucy Letby Letby was sentenced to a 15th whole life order. Whether she will appeal against this conviction, it is yet unknown. So this concludes the timeline so far. Turning on to our second part in relation to her application for permission to appeal, in which we participated remotely. The appeal notice involved essentially 5 grounds. One of these grounds, ground 4, was withdrawn soon after the single judge refused the appeal on paper, therefore we will not refer to it. The grounds were therefore as follows. Ground 1, that the trial judge was wrong in refusing the defense application to exclude the evidence of Dr. Evans. Ground 2, that the trial judge was wrong in rejecting the defense submission of no case to answer. Ground 3, that the trial judge was wrong when directing the jury on harmful acts. Ground 5, that the trial judge did not handle a potential jury irregularity appropriately. Additionally, there was a proposed ground 6 concerning the admission of fresh evidence consisting of 2 reports by Dr. Shu Li, the co-author of a paper, Pulmonary Vascular Air Embolism in the Newborn, which featured heavily at trial. This ground, however, was subject to 2 preliminary applications. One for permission to adduce new evidence under Section 23 of the Criminal Appeal Act 1968, and one for permission to rely on a ground which was not identified on the appeal notice under Rule 36.14.5 of the Procedure Rules 2020. In essence, and as announced on the 24th of May 2024, the Court of Appeal refused Lucy Letby's application for permission to appeal on all grounds, and also refused the application to admit Dr. Lee's fresh evidence. We will see in a moment on what basis, but before that, one general point worth noting is that from the outset, one can see the double standard approach of the Court of Appeal. On one hand, the Court of Appeal states that what was put to the prosecution witnesses in cross-examination was not evidence, save to the extent it was accepted by the witness. More specifically, in the context of this appeal, suggestions made in cross-examination which were not accepted by prosecution witnesses and were not supported by evidence called on behalf of the applicant are, as the respondent has submitted, irrelevant. However, when referring to the insulin cases, the Court of Appeal states that whilst the integrity of the blood samples and reliability of the biochemical testing was challenged by Mr. Myers, who is Letby's counsel, in her evidence at trial, the applicant admitted that both babies had been poisoned by insulin, but denied that she was the poisoner. This, however, is factually incorrect. Lucy Letby, in fact, did not admit that the babies were poisoned, though she did concede that on the basis of the evidence provided by the expert, the bag must have contained insulin. When asked by prosecution counsel whether she agreed that child F was poisoned deliberately, she said, "I can't answer that because I don't know how the insulin got there or who put it in there and why." When questioned by prosecution counsel about child L and whether she accepted that the insulin was put into the dextrose bag sometime between midnight and 9:30 a.m. on April the 9th, she said, "I don't think I can answer that. I am just reliant on expert opinion. I don't know. I cannot answer that. And when prosecution counsel asked whether she accepts that the insulin must have been put whilst the bag was hanging, given that the bag had not been changed, but the blood level continued to drop, she replied, well, if this is what the expert has suggested. So counsel continued in his cross-examination asking, do you agree that the victim had been selected? She said, well, I can't answer that. She is not an expert on the subject and could not have given an expert opinion in this matter outside her knowledge. So this should not be considered as evidence. Now, let's see one by one on what basis the grounds were refused. But before doing so, if you're finding this video informative and useful, then hit the like button below and subscribe to our channel if you have not done so already, to help us with our mission of humanizing our criminal justice system. So going back to the application, first allow me to make two preliminary points. Whilst I'm sure that most of you are familiar with this fact, some of you may not. So here it is. When an application is made to exclude the evidence at trial, two primary issues arise. Admissibility on one hand and reliability on the other. These issues are distinct, and understanding their differences is crucial for a fair trial process. Admissibility refers to whether the evidence can be presented to the court at all. The court must determine if the evidence meets the legal standards and rules for being included in the trial. This decision is guided by various legal principles and statutory regulations designed to ensure that only relevant, legally obtained and fair evidence is considered. The judge plays a crucial role in the determination. Reliability, on the other hand, pertains to the trustworthiness or credibility of the evidence. Even if evidence is deemed admissible, its reliability can be questioned. Reliability does not impact as to whether evidence can be presented at court. Rather, it concerns the weight the evidence should be given. This is typically an issue that is left for the jury to decide. Secondly, in relation to this application to seek permission to appeal, Lucy Letby is the applicant and the prosecution is the respondent. So as to not confuse ourselves with legal terminology, henceforth I will refer to the applicant as either the defense, Lucy Letby or Lucy Letby's team, and the respondent as the prosecution. So with that in mind, let's start by examining the first ground. Letby's team submitted that the trial judge was wrong in refusing their application to exclude Dr. Evans' evidence. Dr. Evans was the prosecution expert at trial, and also he was the expert used by the police during the investigation. In making the application, the Letby's team relied on several arguments. Dr. Evans' evidence was not independent, having been concerned with the investigation. Dr. Evans' evidence did not meet the standard of admissibility for expert evidence. These are listed in paragraph 7 of the Practice Directions 2023, previously covered by Rule 19 of the Criminal Procedure Rules 2020 and Criminal Practice Direction 19A, particularly that the witness must be competent to give that opinion and that the expert opinion must be sufficiently reliable to be admitted. Dr. Evans' evidence had such an adverse effect on the fairness of the trial that ought to be excluded under Section 78 of the Police and Criminal Evidence Act. This states that the judge has discretion as to the exclusion of certain evidence if its effect can affect the fairness of the trial. In short, the defense submitted that Dr. Evans' evidence should have been excluded for lack of expertise, credibility, and independence. The prosecution rebutted that all those criticisms made by the Letby's team were relevant in relation to credibility and weight of Evans' opinion, all factors that should be left to the jury to decide rather than disallow the evidence altogether. Though the trial judge found that at times Dr. Evans was in fact argumentative and frustrated, it did not deem this sufficient to exclude the evidence, and consequently ruled that it was for the jury to make an assessment as to the reliability and credibility of his evidence. The Court of Appeal dismissed this ground on the basis that Dr. Evans did not assume the role of Director of Investigations, but simply provided the police with some guidance and structure given the amount of material provided to the police. Therefore, his independence, the Court of Appeal said, was not compromised. His background made him a sufficiently qualified expert witness. He gave his opinion blind of any of the other circumstantial evidence used by the prosecution at trial, and in any event, his opinion was consistently corroborated by Dr. Bohen. And therefore, the Court of Appeal says, the admissibility criteria as per paragraph 7 of the Practice Directions 2023 were satisfied. Finally, in relation to section 78 of the PACE, the Court of Appeal could not interfere with the judge's decision as this was purely within his own discretion. Therefore, the Court of Appeal concluded that the judge was correct in not excluding the evidence, and that any criticism as to the manner in which the opinion was delivered or any credibility issue could have been easily dealt by way of jury direction. Also, the Court of Appeal noted that the Letby's team did not make any criticism of the trial judge's summing up, inferring that all these issues on credibility and reliability of the expert evidence were in fact discharged appropriately by the trial judge. Now, moving on to the second ground of appeal, no case to answer. This ground essentially related to all the charges in which air embolus was either the sole or a concomitant cause of death or collapse of the babies. The Letby's team submitted that even taken at its highest, the prosecution evidence the babies had died because of an air embolus was not such that a jury properly directed could properly convict upon it. This is because none of the professionals who gave evidence upon this matter were sufficiently qualified to do so due to insufficient or lacking clinical expertise. Incidentally, we agree with this point, and this is the reason why earlier on in this video we described this as medical evidence, i.e. given by professional doctors as opposed to expert evidence, doctors with expertise in that particular subject. Again, the prosecution submitted that this argument went as to the weight of the evidence which was to be left to the jury rather than to its admissibility. The trial judge, in dismissing the defense's application on no case to answer, maintained that the fact that the medical evidence was not of itself diagnostic of air embolus did not attach to admissibility, but rather, again, to the weight and therefore reliability, to the weight of the evidence, and as such should be left to the jury to decide. Letby's team renewed this submission before the Court of Appeal, stating that the level of scientific knowledge did not provide a reliable basis on which to make a finding of air embolus in any individual case. In particular, although witnesses described very unusual skin discoloration on the babies concerned, those descriptions did not provide a reliable basis for diagnosis of a embolus. As such, and in line with paragraph 7 of the Criminal Practice Directions 2023, the reliability of the expert evidence was not a matter for the jury, but rather a condition precedent to the admission of that evidence. The expert evidence on which the prosecution relied to prove the allegation of an embolus should therefore have been ruled inadmissible, the defense said. The Court of Appeal found, however, that in reaching the diagnosis, the prosecution did not rely solely on discoloration. They also relied on other factors, such as the sudden collapse, the absence of other medical explanation or condition. The Court of Appeal concluded that the premise of the submission of no case to answer is therefore, in our judgment, flawed. In our view, the applicant's argument confuses evidence capable of providing a freestanding diagnostic test and evidence consistent with their embolus, which form part of the circumstantial case. In such circumstances, we are wholly unpersuaded that it could not properly be left to the jury to decide whether they were sure, on the basis of all the evidence, that the expert witnesses had rightly excluded other possible cause, that the prosecution had rightly relied upon a number of signs and symptoms, including not limited to skin discoloration, which were consistent with air embolus and collectively inconsistent with anything else, and had correctly concluded that the baby concerned had suffered an air embolus. As part of Ground 3, the Letby's team argued that the trial judge misdirected the jury by telling them that they did not have to be sure of the precise harmful act or acts before they could convict on a particular count. It is customary for the trial judge to discuss proposed jury directions with counsel in advance. One particular submission made by the defense counsel during those discussions was that the jury should be directed that they could not convict the applicant of any count unless they were sure of how the baby concerned had been harmed. He argued that a direction which permitted the jury to convict without being sure of the specific harmful act could lead to a conviction of the defendant simply based on Letby's presence alone. However, the trial judge did not agree, though he amended its initial directions as a result of it. The judge directed the jury as follows: if you are sure that someone on the unit was deliberately harming a baby or babies, you do not have to be sure of the precise harmful act or acts. In some instances, there may have been more than one. To find the defendant guilty, however, you must be sure that she deliberately did some harmful act to the baby, the subject of the count on the indictment, and that the act or acts were accompanied by the intent and, in the case of murder, was causative of death. The Court of Appeal held that given that the Letby's defense was based on the fact that she did not deliberately commit any unlawful harmful act directed at causing or attempted to cause fatal harm, what the jury had to decide was that there was no other possible explanation but the act of the defendant as to the cause of harm. The court therefore concluded that the judge was correct in directing the jury that they had to be sure on the evidence as a whole that the defendant had done something deliberately to harm a baby with the requisite intent as to murder, but that it was not necessary for the prosecution to prove the precise manner in which she acted in each case. Moving now on to ground 5. Ground 5 was based on the submission by the defense that the trial judge did not handle a complaint of jury impropriety appropriately. It was alleged that a juror was reported to have said in a cafe that the jury had already made its mind up right from the start about Lucy Letby. However, when heard by the judge, the juror in question stated that his girlfriend used to be a visitor of the cafe in question, but that she was no longer a visitor due to an incident happened on the same day in which contact with the court was made. She sold a phone to the owner of the cafe, but he failed to pay for it. When she returned to request payment, he had assaulted her and she had contacted the police. This incident was in fact corroborated by the police. Defense counsel submitted that the trial judge, as well as questioning the juror, should have also questioned the complainant. However, the judge decided that that was not necessary. The Court of Appeal decided that it was entirely on the judge's discretion to decide how to deal with that matter. It also found that he had followed the appropriate procedure and both counsel were consulted. Furthermore, the Court of Appeal said the jury had already retired for several days by then, and at the time the jury took to deliver the verdict, and the fact that they could not reach a verdict in some of the counts was at odds with the idea that the jury had already made its mind up. The court therefore concluded that the judge did take the correct approach. Now, finally, turning on to the proposed grounds. Lucy Letby's team made 2 applications. One under Section 23 of the Criminal Appeal Act 1968 to adduce new evidence in the form of 2 reports and attached appendices by Dr. Shu Li, who is considered the leading expert in this subject. The second application was made under Rule 36.14.5 of the Criminal Procedure Rule 2020 to rely on a ground which was not identified on the appeal notice. This would be ground 6, seeking to rely on the evidence of Dr. Li, which, read together with the weak evidence relied upon by the prosecution during the trial in relation to her embolus, would render the convictions from most of the counts on indictment unsafe. Dr. Li was therefore heard de bene es, which means that he was heard provisionally and conditionally or subject to those 2 applications being allowed. In essence, Dr. Li said that only one type of discoloration can be diagnostic of her embolism. That was the one described in the paper Pulmonary Vascular Air Embolism in the Newborn, of which he was one of the 2 authors. Earlier, when introducing this ground, defense counsel had stated that by the end of the trial, almost any type of discoloration was considered by the prosecution as diagnostic of her embolus. This was also the reason why Dr. Li's evidence, said the defense, was called only at this later stage. This was because the prosecution case essentially changed from the initial submission that only one type of skin discoloration was diagnostic of her embolus to then embrace many types of discoloration. However, the prosecution contended that skin discoloration was not considered by the prosecution as diagnostic of her embolus, but rather indicative of her embolus only when taken into account with other factors such as the sudden decline or the collapse, which could not be explained by other medical explanations. Dr. Lee also added that exclusion diagnosis is not a gold standard to establish air embolus. In other words, air embolus could not be diagnosed on the basis that no other explanation fits. He warned about being humble in accepting that there are certain things that we cannot simply explain and which we may be able to explain in future. In short, Dr. Lee's evidence was that air embolus is a very rare and specific condition and should not be diagnosed by excluding other causes of death or collapse and concluding that it must be a case of air embolus because nothing else could be found. Dr. Lee was asked by the defense counsel whether the descriptions provided at trial by prosecution witnesses in the cases of baby A, baby B, baby D, baby I and baby O, which Dr. Lee had reviewed previously but which counsel read aloud to him in open court, whether these were consistent with air embolus. He confirmed in each case that they were not. The prosecution criticized Dr. Lee's evidence relevance on the basis that he did not look at all the evidence and material available for each of the specific cases, material which both Dr. Evans and Dr. Bohen and other prosecution witnesses were privy to, reiterating that the prosecution expert witnesses did not treat skin discoloration as in itself diagnostic of air embolus, but instead took it into account as consistent with air embolus and adding to the other clinical circumstances which excluded other possible causes and pointed to that diagnosis. The Court of Appeal found that the delay in calling Dr. Lee was not accepted, as the defense had ample opportunity to seek expert evidence from Dr. Lee or other expert, given that all the prosecution evidence, with the exception of one baby, was provided by February 2023, a good 3 months before Lucy Letby gave evidence. This was, of course, a point that the Court of Appeal was entitled to make. However, what came next was, in our opinion, astonishing. The Court of Appeal stated at paragraph 187, but even if the applicant could persuade us that there was a reasonable explanation for the failure to adduce Dr. Lee's evidence at trial, she faces a further and, in our view, insuperable obstacle. Even accepting for present purposes that Dr. Lee is correct in his opinion that only one form of discoloration is sufficient in itself to diagnose air embolus in a neonate, the proposed fresh evidence cannot assist the applicant because it is aimed at a mistaken target. The core of the proposed evidence is that, save for that one very form of discoloration, it would be wrong to diagnose air embolus on the basis of skin discoloration alone. But, as we have said when considering ground 2, there was no prosecution expert evidence diagnosing air embolus solely on the basis of skin discoloration. Dr. Evans and Dr. Bohen relied on the differing forms of skin discoloration observed in individual babies as consistent with air embolus. Their evidence in that regard was, in our view, entirely consistent with the observational study in the Lee and Tansel paper and with Dr. Lee's review of 64 cases since the paper was written. Indeed, Mr. Myers realistically accepts that skin discoloration other than the one type which Dr. Lee states is pathognomonic of air embolus. is indicative of circulatory collapse, which may be associated with an embolus, and that air embolus may be associated with a variety of skin discoloration. In short, the prosecution witnesses did not fall into the error which the proposed fresh evidence seek to assert they made. The proposed evidence is therefore irrelevant and inadmissible. By making this statement, in our opinion, the court effectively assumed a role beyond its judicial capacity, positioning itself above the expert witness. In doing so, it stepped completely outside its prescribed function, essentially acting as a super expert capable of overruling the testimony and professional judgment of the actual expert. This action not only undermines the expertise of the witness, who is specifically qualified and knowledgeable in the field, but also sets a concerning precedent where the court substitutes its own judgment for that of a specialized professional. This overreach disrupts the balance of the judicial process, where the evaluation of expert evidence is intended to be left to those with the appropriate knowledge and experience. Our overall view of the judgment is therefore mixed. While we agree with certain points made by the court, such as the fact that the defense counsel's failure to question the jury directions given by the trial judge is capable of rendering grounds 1 and 2 redundant, and that Dr. Lee's evidence could have been sought earlier, we believe that in the interest of justice, Dr. Lee's evidence should have been admitted. In our view, the combination of ground 2 and 6 presented a strong argument to question the safety of the convictions. This leads to our overall disappointment with the judgment, which reveals once again the Court of Appeal's obstinate position to protect jury verdicts at any cost, even in cases where the task given to juries transcend their capacity. Here, the jury, having been provided with substandard medical opinions, were effectively left to draw their conclusions based solely on flawed circumstantial evidence. This approach not only undermines the integrity of the judicial process, but also raises serious concerns about the fairness of the trial and the reliability of the verdicts. Given the latest developments following this secondary trial, there appears to be a shift in mainstream media, which now seems to entertain the view that Lucy Letby may be innocent, an idea once dismissed as conspiracy theories by disillusioned scientists. This shift reinforces our uneasiness about this case, which we first highlighted 9 months ago in our video Criminal Evidence Roulette: The Risk of Statistics, and continued to explore in subsequent videos, such as Lucy Letby Inquiry, How Far Will He Go?, Lucy Letby Last Freedom Bid, and Open Justice, Lights, Camera, Action. All this video can be found linked in the description below. We are hopeful that further stronger evidence, which the jury was not privy to, can be finally combined, including the flaws in the statistical evidence repeatedly pointed out by Professor Gill in relation to clusters of death in hospital settings and duty rosters, or other concomitant factors such as medical malpractice. This new body of evidence could form the basis for an application before the Criminal Cases Review Commission in the near future. This analysis concludes our video today. I hope you have found it interesting, and if so, like it and consider subscribing to our channel to help us in our mission to reach more people and humanize wrongful convictions. Also, join our networking hub to have your say as to the content of this channel and to engage in discussions about the criminal justice system. Be part of the change. Join us again next week when we will meet Michael O'Brien, who spent 11 years in prison for a crime he did not commit. We look forward to usher you as we sit and rise in this unique trial.